Okay, so I'm starting the broadcast in 5, 4, 3, 2, 1, and
The broadcast is now starting. All attendees are in listen-only mode.
okay, well, welcome everybody. Hello. Hello, and welcome to today's webinar, IPR Protection for EU SMEs in the toy industry. And this is brought to you by the China IPR SME Helpdesk and the Toy Industries of Europe. My name is Philip Healy, Helpdesk Project Manager, and I have the pleasure of being your webinar moderator today. And joining me shortly should be our expert Maarten Roos, who will take us through today's topic. Okay, well, just really to explain to you how you might be able to use the webinar what we call interaction tool. I'm just going to really explain to you how this works. So throughout the presentation, we're going to ask you to interact with us by typing in questions and comments using this question pane that you have on the right side of your screen. And we'll have the ability to answer these questions during the presentation, live, and also after the presentation should need be. We're going to take the platform for a little bit of a spin, just to gauge your attendance, and I'd like you to all raise your hand using the raise hand options you see on the top left of your interaction tool. You should be able to all see it there, top left, the little hand sign. If you could all click that hand sign there, then that will give me a good understanding of whether you can hear me, whether you've understood what I'm saying. Yeah, Jay, everybody's clicking? Okay, perfect. We actually nearly verging on to about 40 people today, 40 attendees, joining from China and across Europe. Jay and Ben, my colleagues, are part of the support team today and are on board to answer any questions you might have in the question pane there. If you want to intervene, if you want to ask a question in Q&A, we're here to, if you have problems in terms of connection or whatever it may be, we're here to help you out, so don't hesitate to use that question pane. One question we always get is, can I have access to this webinar after the session today? Absolutely. We have a recording that will be available in the next 2 days, and we'll obviously send you the presentation by email as well. Okay, the webinar will be downloadable from our website and from the TIE website following that. So, just a quick introduction for those of you who aren't familiar with the China IPR SME Helpdesk. We are a project funded by the European Union. Our services are free, and we provide what we hope is jargon-free, first-line, confidential advice on intellectual property issues in China to European small and medium enterprises. Okay, so basically we're here for small biz, and our services include an inquiry helpline. That means really answering your IP-related questions related to China. We organize a number of events. Hopefully you've been able to attend. Well, you're actually attending one right now. We do these across Europe and China, and obviously on the web. We provide IP materials, so on the website you'll be able to find guides, newsletters, a case study catalog, all of which deal with issues relating to IP in China. We hope and aim for these to be practical and really reach out to small businesses such as yours to answer those most important questions when it comes to China IP. Remember to connect with us on social media sites, Facebook, Twitter, and LinkedIn. Okay, well, I'd like to really move on to today's speaker, Maarten Roos from RMP China Lawyers. Maarten, are you with us?
I am.
Oh, hello, Maarten. We can hear you. I hope everybody can hear you loud and clear. Please let us know if that's not the case. Today, Maarten will be running through those IPR issues for companies in the toy industry. And Maarten, it's great to have you today. Can maybe just obviously a lot of us can see the slide with a little bit of an introduction to yourself, but if you could just tell us about yourself, that would be great.
Absolutely, Philip. Thank you for this opportunity. Welcome to everybody in Europe and in China listening. Very briefly about myself. I'm from the Netherlands. I've been in China for 13 years. 10 years ago, I started working for a Chinese law firm, and 2.5 years ago, I established my own Chinese law firm. Always, we have been supporting foreign businesses, mainly SMEs, and predominantly from Europe, on legal issues in China. And so companies which are investing in China, but also companies who are trading with Chinese partners, and I believe that a lot of our listeners might be interested in this, companies that have IP interests in China, for example, and rights that need to be protected. Very briefly about our law firm, a firm I founded. We're right now with 16 people, and very much focused on not so much a practice area, because we're broad, comprehensive in that field, but a kind of client. A typical foreign client who wants to have one good, commercially oriented lawyer who provides practical solutions to his legal problems. Our clients want quick solutions. They want to move on with legal issues so that they can focus on making money. That's us.
Thank you, Maarten. Okay, well, maybe I'll also let you present today's agenda, and then once you're done with that, once our audience has a good understanding of what we're going through today, I'll go through a few polls, just really to gauge who we're talking to today. Okay, so the agenda's yours to present, Maarten.
Excellent, Philip. What I'd like to do today is, we don't have a lot of time, and I'm sure that everybody's busy, so we want to keep it short and sweet. What I want to do is introduce to you the 4 key steps and that we see clients come across and can use as guidance to tackle infringements. We're not focusing only on registration. We're really trying to focus on what can companies do to tackle, to do something against infringers who are operating from China. These 4 steps, the first one, establishing IP rights, extremely important. Without the IP rights, we don't have to go to the next step. The second one, to understand what are the infringements, who are the infringers. The third step, all important in the Chinese legal system, is to collect the right evidence. And fourth, of course, choosing the best strategy, whereby our listeners will learn that there's actually quite a lot of opportunities or options for them to take. And of course, the key to a successful strategy is to choose the right steps to finalize it and to get your market free from infringers.
Okay, fantastic, Maarten, and so look forward to it. But before we get go with these steps, let's get to know a little bit better our audience. There's quite a few of you, and what I can see, it's really from all over Europe. And so first of all, what we'd like to do is ask you a question, really just to get to know you. And so I assume you're all from more or less the toy industry background. So really, what are your business activities in relation to China? So this is a multiple, you can choose one or several options. No, it's just one option, of course, sorry. Are you manufacturing in China? A, are you B, selling and distributing in China? Both of the above. C, are you considering entering the Chinese market? So basically, where do you find yourself in that cycle in terms of dealing with China? I'll leave you a couple of minutes there just to start voting. And it looks like we've already got 65% of you voted. I'll leave you a couple of seconds there. So take the time. Actually, no, hurry up and answer those questions. And I'll kind of share those results, obviously, with you all and with Maarten. But it's certainly looking like, well, it looks like actually 36% of you seem to be saying that it's something else than A, B, C, and D. If you wouldn't mind actually telling us what that other is by using the chat function, then that would be great. Because currently we have, it seems, 20% of you that manufacture in China, 8% of you who are selling distributing in China. 16% are doing both. 20% are still considering working in or with China, and 36% seems to be another option. So don't hesitate to reach out to Jay and Ben and tell us what that other side of what you're doing in terms of activities with China is. So it's quite a fair spread there, Maarten, right?
Yes, indeed. I would expect that the others, maybe a portion would be not doing anything particular in China, but seeing a lot of infringements coming from China, which would indeed say no business activities, but certainly an interest in Chinese IP. And for those, obviously, I will be looking at that issue as well.
Yeah. Okay. Well, that's actually our second poll in a sense. Well, no, actually, that would be a third poll. Actually, our second poll is more to do with the fact with what have they done in terms of IP. So, what intellectual property related measures have you, the audience, already taken in China? Now, have you registered any IP in China? A trademark, for example, any designs? That's answer A. Have you registered with China Customs? Maybe. Have you signed confidential agreements with Chinese partners? Maybe. Or none of the above. This is obviously a multiple choice. So go ahead and let us know what you've done so far. That will also give Maarten, myself, and the rest of the team a better idea of where we're at, what might be the problems on the horizon. And then obviously we'll have a third poll later on that will deal a little bit more with infringement and what may have been your experiences there in terms of dealing with infringement and if you've taken any enforcement actions. But that's our third poll, and that will be after Maarten's first intervention in step one. But right now, in terms of what we have in terms of results here, with about 80% of you voted now, is that it seems 55%, a really healthy amount, has registered some IP in China, which is quite promising. 23% of you have registered with China Customs, and 41% of you have signed confidential agreements, and 32% have done none of the above. Okay, so fairly encouraging results there in terms of at least 50% that have registered IP in China there, Maarten.
Yeah, let me take over the point. You call it encouraging. I'm certainly happy that a lot of companies have been doing their homework. I would be a little bit concerned about the remaining 45%. Of course, there are companies that don't need to register, but for my presentation today, I hope it will be clear that they still need to make sure that they are in the right category. Today, to the introduction, why are we here? I mean, I think there's two key reasons why the toy industry is interested in IP infringements or IP protection in China. Number one, and the second point on my slide is I've heard a statistic that 85% of counterfeit toys in the EU are imported from China. And that's a huge amount. So basically what we're seeing is that if toy industry members who are operating in Europe, who are selling their products there, have problems with counterfeits, then they are very likely to come from China. The second issue, and from the poll it seems that this is still relatively new to our listeners as well, is that China is of course an extremely large market. The toy industry, while we walk around, it's all very underdeveloped. And so for a lot of companies, IP infringement might be a problem or a concern on the way to try to tackle this market. In any case, whether it's for A, for B, or for other reasons, I think that we're listening here or you're listening to me because protection to IP matters. And so this is, let's say, the basis of the premises of what we're talking about today. When I say IP matters, it also means that we need to have IP. What some companies, they do make the mistake of waiting too long with registration or trying to establish IP in China until it's too late. Take trademarks, for example. The trademark system in China is very much similar to trademark systems in other countries. There is, however, a difference between some jurisdictions, and that is that China is a first-to-file system. That means that whoever registers or applies for registration of a trademark first has the first right to get that trademark. There are some exceptions, of course, but as a result, in China, where IP infringement and counterfeiting have become so popular, there's also a lot of businessmen who specialize in finding trademarks that they register, and then they wait until the real trademark owner from Europe, from the US, from other foreign countries comes to China, and then they basically blackmail this party into paying a lot of money or not being able to use the trademark. So from this perspective, also, it's important to be as quick as possible in registering your trademark. Okay, 55% of you have already done that. Excellent, or at least probably have registered at least a trademark. Some of you might still need to consider this. From that perspective,
just a second, Maarten.
Yes, sure, of course.
Sorry, just to intervene. I mean, we've had a few questions, and I think a few guys here are also got a little bit confused with some of the acronyms that we've been using. But you know, by IP, obviously, what we mean, guys, is intellectual property. It's those intangible assets, those trademarks, those designs, those patents, those trade secrets that you have as a business. And by SME, we mean small and medium enterprises, basically small businesses, okay, which are at the heart of the European economy. I think it's in regions of 90% of companies, even more, 99%, I think I was reading the other day, are what can be considered small and medium enterprises. Just to clarify that with our audience.
Okay.
It's all
Thank
yours,
you very much for that clarification. Yeah, maybe I was going too fast. My apologies. This is the first webinar I'm doing, and I'm used to looking at the faces of my audience and understanding whether I'm going too fast or too slow, or whether I'm putting them to sleep or not. So bear with me, or interrupt me if you feel I'm going the wrong direction, or if questions are asked that should lead me to another direction. Indeed, I mean, I went directly to trademarks. Basically, maybe a step back, we're talking all about different kinds of intellectual property rights. Here in this slide, I've determined, based also on discussions with other companies in the toy industry, that probably the most important intellectual property rights for you are trademarks, design patents, and what we call trade dress. And basically, this is, let's say, the packaging, or what makes something look like your product without actually using, for example, a trademark. When it comes to these IP rights, trademarks, definitely you need to register them. If you do not register your trademark in China, you simply don't have that right, and you also risk that somebody else takes that right and tries to prevent you from using your trademark in China. So definitely a very important step in the whole intellectual property enforcement process. For design patents, again, this needs to be registered. Similar to most countries in the world, if you come up with a new design which is special, which is different, which you want other parties to avoid using, then you need to make an application with the relevant authorities. In China, it's the State Intellectual Property Office to register that patent. It's not a complicated process. However, it does take a while. It's about a year for a design patent, which means that you only try to register things, designs which are really quite unique, which are special, which you want to protect for a longer period, and which is not, you know, briefly special and after a year no longer valid. In my own review of toy industry challenges, I came across a lot of companies who are worried about trade dress. Basically, what they're seeing is that they're seeing in the market, in their own markets in Europe, they see a lot of products which look very much like their own products, but are not using the same trademark, that are not using any registered patents, but basically are a copy. There are different kind of names in to this. In the United States, we refer to it as trade dress. I think that in Europe, you sometimes call it parasitic copying. In the Netherlands, we call it slaafnaambootsing. All different names for the same. A product which very much looks like your product due to the appearance, for example, of the packaging or the labeling. That is a very different and quite difficult kind of intellectual property right to protect. Because in the Chinese legal system, this cannot be registered. The only way that you can protect trade dress is under the unfair competition law, basically saying that if one party takes advantage of something that you have created, and that's unfair competition, and you can take action against him. However, there's a condition, and this is extremely important to keep in mind, that your product needs to be famous in China. So trade dress protection is not available, for example, for European companies who focus only on the European market, because by definition it means that you're not famous in China, and so this IP cannot be enforced in China. Of course, all my discussion here is only about enforcement in China, trying to tackle infringers who are established in China, perhaps factories, perhaps trading companies, who either try to bring these infringing product counterfeits onto the Chinese market or export them to Europe. So you might be able to still protect in Europe your designs, your trade dress, your trademarks. That has nothing to do with what I'm talking about today. And that's registering your IP right or protecting your IP rights in Europe. But when it comes to trying to tackle a Chinese company directly for an IP infringement in China, then trademarks registration, not a problem. Design patent registration, not a problem, though a little bit more difficult. Trade dress, very difficult unless you're very well known in the market.
Okay.
Besides these three, sorry, you have a question? Yes, of course.
Yes, sorry. I mean, are we moving on to locating infringement and infringers? Because if that's the case, maybe we can launch our next poll, which is basically
absolutely.
Yeah. Okay. Well, let's do that. Let's do that. And so basically, our next poll is: have you encountered infringement, and if so, have you taken action? Okay. So Jay's going to launch that poll, and similar to the two previous polls, and this will be a good introduction to Maarten's next section, which will be dealing with locating infringement and infringers. So basically, have you encountered infringement counterfeits originating from China? If yes, have you taken any IPR enforcement action? Answer A, no, I haven't encountered any infringement. Answer B, yes, but no enforcement action taken. And answer C, yes, and I have taken IPR enforcement action. Okay, so we'll let you go ahead there. I'll give you a couple more seconds. Okay. So what we have is quite a fair divide between no, I haven't encountered any infringement, and yes, and I have taken IPR enforcement action. So that's 40% on each side, basically, with 15% or so who say, yes, I have encountered infringement, but I have not taken any IPR enforcement action. Okay, so back to you, Maarten.
Thank you, Philip. This is an extremely interesting poll, and thank you for introducing it, Philip, because this gives me a better idea of the level of experience of our listeners. The difficulty is that the result is fairly even on people who have a lot of experience and people who have no experience, which makes it obviously a little bit more difficult to find a balance. I will try to find that balance anyway, but I would encourage people who feel that their questions, because of this balance, have not been answered, to raise their questions on the system, so that Philip can pass them along and I can respond to them in my discussion. having said that, when it comes to infringement, I think that the first key is to understand what's going on. I mean, I do come across a lot of companies who say, yes, my IP is probably being infringed. I noticed something. I'm not sure. This is very difficult information to do anything with, and because frankly, the start is with who is doing what is important, what is not important. And considering China is such a big market, such a big country, 1.4 billion people, many different jurisdictions within China, you can't try to clean the whole market from every single counterfeit product. I mean, you can't do that if you do DVDs, and you can't do it for any product. So what you need to do when you try to protect your business against infringers in China is you need to have information, and the more accurate that information, the easier it is to respond to that. I think it's useful to look at a little bit at the sources of information, because it's not always that obvious. The first source of information for a lot of our clients is sources at home. They see that in their markets, certain products are coming, and they can easily identify where are these products coming from. They see that companies are exhibiting products on trade fairs in Europe, or they see that their customers are buying products from other parties all of a sudden. It's often quite visible what's going on there. And that, of course, because the European markets are apparently, for our listeners, quite important. This is really the first step to try to understand that information. On the other hand, there's also plenty of sources in China where you can get initial information of what's going on. Trade fairs is probably the most important. As you may know, in China, a lot of trade fairs are organized every year. Big ones such as the Canton Trade Fair twice a year in Guangzhou in the south. In Hong Kong, you have trade fairs, in Shanghai, in a lot of different cities. Right now, I'm in a trade fair in Dalian for food stuffs. I mean, everybody organizes trade fairs in this country just to bring that huge market together with the huge supply. Trade fairs are invaluable information for a lot of our clients to understand who is doing what on the infringement side, because trade fairs are such a huge marketing opportunity for factories, trading companies in China who are trying to reach so many of these foreign customers. So that's one. A second, particularly for your industry, the way that toys are sold in China might be helpful. In Guangzhou, for example, in the south, where I've lived for many years, and you have one or two, let's say 2 or 3 markets which are completely full of toys. These are, let's say, 4 or 5 buildings in a block which only sell toys. Wholesale, retail, and whatever they can find. It's a typical way of how wholesale and retail are organized in a country like China. They're all put together so that it is easy for buyers to find and compare. Now, for you, I believe also that is extremely important, because it means that you can easily try to find out who is doing what, who's selling which products. These toy markets, because they're also focused on wholesale, you can get to the manufacturers through these toys markets as well. Of course. Yes, of course.
Maarten, just a quick question, really. I mean, first of all, a pointer to our audience. The China IPR SME Helpdesk has quite a comprehensive guide on what to do in terms of preparing for a trade fair, what to do when you are at the trade fair, and what to do once you've left the trade fair, particularly when it comes to counterfeit products. So this is available on our website. But I'd like to also ask you, Maarten, and I know you just moved from the toy market, but in terms of trade fairs, have you found the IP desks to be quite useful at the trade fairs? Because there is supposedly always an IP desk at the trade fair where you can file a complaint. In your experience, has this been a relatively easy affair? I mean, I know that sometimes it's been a case where they're quite well hidden at the trade fair, so finding them can be a bit of a challenge. But in your experience, what is it like?
Philip, excellent question. What I'd like to do is, and I think that I might be going a bit too slow on this then, is because my on the evidence collection and in the taking actions, I was trying to discuss these things in a little bit more depth. Would you mind if I postpone my answers till then?
Absolutely not. Absolutely not. Let's do it like that.
Because I will point out, and I'll certainly give you my opinion on how efficient or lack of efficiency some of these trade fairs have.
Okay, Martin. Okay, let's tackle it later then. No problem.
Yeah, I will get on it very quickly. I just want to make one point on this locating infringers at this part, step 2 in the process. In the end, salespeople is another area. Competitors, customers, they might have information. Another source of information is Alibaba, the websites on which a lot of sales is being done. There is a wealth of information quite easily accessible. It is very difficult for your lawyer, for example, to go through this information because he charges a lot of money and he spends a lot of time trying to understand your business, while in fact you understand it much better. So I would recommend that if companies notice infringements coming from China, and that they start with spending a little bit of time at just making an overview of who's doing what. I can give you some examples. I think I'll provide them maybe a little bit later. But there is cases which have been extremely successful in IP enforcement, exactly because that is what they're trying to do. And he understands his market. He understands who's doing what, which are the important, which are the small ones, why are they doing it. And that kind of information means so much in making a strategy of enforcement effective, also cost effective. Basically, it means you don't have to fight 100 battles, you have to fight a few battles, which are the most important, and everybody will follow along. So that's step 2 then. Step 3 is relating evidence. I mean, you might have a lot of information, that might not be enough to move forward. Chinese court systems and to a lesser extent, Chinese administrative authorities who might also play a role in this, trademark bureaus at the trade fairs, IP bureaus at the trade fairs will also have a role in the enforcement. They all get triggered by one piece in evidence. I mean, I know that there's a lot of discussion or views going around that China is based on relationships. It's based on who you know, not what you sign. There is a sense of truth on that. I mean, relationships are important, but when it comes to enforcement cases, so cases where you really have to get something done and the opposing party is not going to be happy, the best way, the only single way to convince government authorities and courts to support you is to show them the right evidence, to show that your IP rights are being infringed, and to convince them that, look, you have two choices here. You can say no, but then I'm just going to make your life even more difficult. And you can say yes, and based on the evidence that I provide you, that's what you should be doing. So evidence should never be underestimated. It means that when you're doing your research and you collect everything, however, that might not be enough. What kind of evidence are we talking about? One is, of course, of the IP rights. A example of a case, I've got a client, a Dutch company, who is ready after many years to take action in China, to administrative actions and court actions. And what they found out, and we just started working with this client, they got 15 trademarks in China, but they never applied for the trademark certificate. Now, in China, you need to be able to prove your IP rights. Also, for example, in the trade fair action, when you meet an IP desk, you need to be able to show this is my right. This is not. It's not enough to have a printout from some kind of website to say, look, this is it. No, you need to have meet a fair burden here and to show that indeed you have the rights to certain IP. And when it comes to trademarks, this is in the form of a trademark certificate. Even if you're registering from abroad through the international Madrid system, you need to apply for trademark certificates in China to ensure that you can enforce in China. In the case of patents, this is patents or patents. This is also in the form of a registration certificate. In the case of copyright, this could be registration. It could be also some pictures, but you need more. So that's a key issue that you need to prepare for before you start an action. The second, of course, is evidence of the infringement. Now, when it comes to trade fairs, for example, it is great to make pictures, to collect brochures. I mean, if somebody is using your trademark and you collect a brochure where that is clear, then that can be extremely useful evidence. I would encourage it. It might not be enough. It might not be enough, for example, for a civil case, because there, if you just provide a copy of the brochure, then a court might say, I have some noise here, but okay. And the court might say, yeah, but this is not so convincing. So there are things that you yourself can prepare. Another way is to use a public notary. A notary office in China can go with you to a purchase, or they can notarize a web page, for example, to confirm an infringement. So what we often do in the case of infringements found online, for example, is that we arrange for a public notary to certify, to authenticate that this infringement is taking place. Now that's excellent evidence. A third level of evidence, and that goes one step further, is in some cases it's very difficult to collect extremely good evidence. In some cases, for example, I mean, it would be easy if you're in consumer products, you can go to a store, you can purchase something with a notary officer there. But in some cases, it's very difficult to do that, for example, because they're only exporting or they're selling only wholesale. What can be a very good solution is to get the government authorities to help you collect that evidence. That is an option in China which can be extremely successful to avoid very basic problems in trying to reach infringing products.
Okay, just a quick
intervention
there, Maarten. Sorry to intervene. I just really want to make a bit of a shout out there to all our audience, just to make sure that you all know that through the chat function you can ask us questions, because we've got another 10 minutes of presentation, more or less, and then we'll move on to our Q&A session. Now's the time really to send in a question to Ben, Jay, and I. So don't hesitate to do so. I'm sure you all have quite a few questions. Maarten, it's back to you.
Thank you.
Sorry. Yeah.
We were talking about actions. That's probably the most complicated, but also perhaps the most interesting part of indeed an enforcement strategy, because that's where it ends. I mean, let's say the first step is that you need to have certain things in place. I mean, we already talked about evidence, for example, of IP rights, such as trademark certificates, patent certificates, other evidences. Second point is to have, for example, powers of attorney in place, a certificate to show that your lawyer, for example, can represent you. I mean, these steps, I don't want to lean on them or put a lot of focus on them, because I think it's pretty obvious. But we do notice that sometimes companies forget this step and want to move too quickly, while a good preparation in this area is, of course, extremely important. Then, of course, it is to decide what you want to do. Now, I want to take a step out of, let's say, the 4 steps that I discussed, and just simply look at what are the kind of actions that you can take. The first, I mean, you've all heard of it, a cease and desist letter. Basically, a letter, for example, by a lawyer to tell a company, please stop. If you continue, I'm going to sue you. I'm going to make your life miserable. You're going to go to prison, etc., etc. The first point to note that I was speaking to a U.S. lawyer a couple of months ago, and he said that in the U.S. cease and desist letters never work. In China, you have 2 kinds of responses. You have companies who say, I don't care, sue me and we'll see. And you have companies who say, well, I don't want to make problems. It's surprising how often we get positive responses from cease and desist letters. Now, certainly this is not 80%. I would say more 20, 30, 40% of responses, of which maybe 20 or a total 20, 25% is very, very positive. But a cease and desist letter is a cheap way to try to see whether you can get something out of it. And I can give you just a very brief example. I had a client who at a trade fair came across a copyright infringement. I mean, this company was basically taking pictures and putting it as a brochure, but a little bit different. The problem with copyright in general is that it is quite difficult to prove. And second, at trade fairs bureaus are not so interested in copyright because of the evidence burden, and that kind of answers a part of your earlier question, Philip. That IP desks, you have to make it easy on them. You can't make it too difficult. If you say, yes, my rights are infringed, but you can't really prove it so well, then it becomes difficult. And so trademark infringement, for example, are much more successful, or trademark actions against trademark infringement at trade fairs are much more successful than, for example, patents, certainly, and copyright. But just back to this case, I mean, we didn't have much of a case, and we didn't believe that we would win this case. But the client really wants to do something, and so we said, well, let's send a letter. And to our surprise, or maybe somewhat to our surprise, we got a quite aggressive response where the infringer said, we didn't even know. This was quite a big company, and for them, this part of the business was relatively small. They did business with a lot of international companies. They didn't want to have the black mark of being pursued for an IP infringement, even if they probably knew that we couldn't do much about it. They still felt that this kind of information was useful enough for them to stop the infringement. So never ignore this option. I mean, it's not necessarily the best option, and in some cases we would advise against it because other actions are more effective and we don't want to warn the infringer. But in cases where other actions are not worthwhile, I think it's always worthwhile to consider whether a marginal cost of 3, 4, 5,000 RMB, and let's say 400 or 500 euro is worthwhile to try and to get something done. What I would suggest is that to always have a cease and desist letter in China written in Chinese and by a Chinese law firm. Basically, if you send it from Europe by yourself in English or in another language, the chance is that much smaller that you will get a response. That's the first. The second, if I may go right along, is administrative action. Now, I mentioned before a government authority who can take action in helping you collect evidence. An administrative action is basically a complaint to a government authority with preliminary evidence. So, for example, pictures might be enough. You prove your IP right and you show initial evidence that somebody might be infringing it, and with that you may be able to convince a administrative authority to take action, to go to, in the case, for example, of trademarks, to go to an infringer, to look around there, and to determine whether indeed your trademark is being infringed. If so, then such a government action, a government authority can seize infringing products. They can even relay a fine. They can put a penalty there. They might even destroy the infringing product. They might also even close the factory, close the infringer. All different possibilities. What they can also do is the evidence that they can find during their action, and you can find a way to get that evidence so that you can start a civil lawsuit to try to get compensation. So an administrative action in a country like China, where government authorities play such an important role and are so relatively highly regarded, an administrative action by a government authority can be an extremely efficient way to tackle an infringement. So it's less strong than a lawsuit because, for example, you cannot get compensation. It's cheaper, quicker, it's more direct, and it could get a lot of results. There's different kinds of administrative actions. I don't want to get into it in too much detail. There's one particular that is interesting for a lot of our listeners, probably, that's a customs actions. Now, a customs authority is interested in looking at IP infringing products which enter the country or leave the country. So for a company, for example, that has IP in China, who is seeing a lot of counterfeit products coming from China into Europe, they can consider to record their trademarks with the Chinese customs to make it easier for Chinese customs to find out whether infringing counterfeit goods are passing through their hands. And if they do find these infringing goods, then they will stop the shipment and they will give you a call or give your lawyer a call and say, well, do you want to do something about it? Do you want to take action? And so instead of having you to find out who are the infringers and taking a lot of action, basically you have your customs who is doing part of that work for you. What you I mean, you actually don't need to record your trademarks or your other IP rights with customs to take advantage, but it is strongly recommended, and because it makes it easier for customs to find your IP rights and contact you and try to follow up on that. So another particular kind of administrative action is what you talked about, a trade fair action. Maybe to start immediately with your question, are IP bureaus at trade fairs effective? I think that there's a couple of levels to that question. The first is what kind of trade fairs are we looking at? When you look at state-level trade fairs, for example, the Canton Trade Fair in Guangzhou twice a year, the biggest trade fair in China. This is a government-level trade fair, and this IP booth is directly manned by officers of the trademark, or the IP bureaus in Guangzhou. So these officers have it's their job to do something about it. They also have a direct interest. They also have quotas to work with, so they actually have to do something. So generally, these people respond quite quickly. What you do need to give them is you need to show your evidence. So you can't just walk in and say, hey, somebody is probably infringing, do something about it. No, you have to show your IP rights, for example, in the form of the trademark certificate, and you have to show that somebody is infringing it. You have to give them 24 hours to respond. But we have plenty of cases and examples where we have helped clients to make a complaint with an IP desk at, for example, the Canton Trade Fair, where they've been very effective in immediately taking action in either closing the booth or taking out all the infringement goods. That's one kind of thing. But when you look at more private trade fairs, the smaller ones, the smaller exhibitions, there the IP desks are extremely ineffective. The reason is very simple. They don't have a mandate from above. I mean, they are ordered by law to have IP desks, but they are in fact working for the trade fair organizers. And the trade fair organizers, they are not happy that exhibitors are tackled. These exhibitors are paying them a lot of money to exhibit, and there you are ordering this guy to go away. Well, he's certainly not going to come back next year. And if this, let's say, information spreads, and then other exhibitors might be wary of exhibiting there in the future. So at smaller trade fairs, this is much more difficult. There, I would say the IP desks are window dressing, but they're unwilling to do a lot. And even if they were willing to do something, they always have to balance the interests of their bosses, the people who are paying them money. From that regard, well, you are likely to be on the losing end. Another aspect in that is that the smaller trade fairs are usually shorter. The shorter the trade fair, the less effective the trade fair action is, because take the Canton Trade Fair, for example. If a company is there to exhibit for 5 days, they pay a lot of money to exhibit there. If on the second day you stop them, then they make a lot of loss. And they can't reach their market, and all the customers that they've invited can't find them. And this is an extremely harsh result for them, which won't make them happy, which will make them think of will I do this next year, and can be an extremely good result to an IP owner. On the other hand, the smaller trade fairs where it takes longer, so maybe on the third day you can get them to go away, and fourth day they're already gone, so it doesn't make that much of a difference. So again, there that has a big effect on the strategy there. Maybe do you feel that answers your question, Philip, on the trade fairs?
Yeah, absolutely, and it was really interesting to hear your insight on the different sizes of trade fairs. Of course, you know, the differences there and different reasons why would be the desk would be efficient or not. But yeah, I mean, Maarten, we have about, I'd say we already passed the 45-minute mark, so maybe if we could wrap things up on the in terms of taking actions and a bit of an overview of the key messages, that would be great, because we actually do have quite a few questions.
Okay, I do look forward to that. We've discussed cease and desist letters and administrative actions, various sorts. Of course, what is also available to IP owners is a civil lawsuit. Basically, a lawsuit in court filed against an infringer and based on certain evidence to ask for compensation and to ask for an injunction. Civil lawsuits, not a problem. You do have to consider where they are filed. I mean, local corruption is a problem in certain areas in China, certainly not everywhere, but the bigger the city, the easier that is. What is also a key issue is evidence. I mean, you cannot win a civil lawsuit if you cannot really document in a proper way your rights and the infringement. A third point that deserves mention is compensation. Chinese courts are conservative. They don't award a lot of damages, and so a civil lawsuit is often just as much about the message as about trying to get some kind of money back in compensation for the infringement. Finally, we have criminal prosecution. Now, I would say criminal prosecution is by far the most effective if you want to hurt infringers and keep them from doing it ever again. However, criminal prosecution is also the most difficult. The first issue is that there are certain standards that need to be met. This is not so easy. It depends on exactly what kind of infringement. So I won't go into that in detail, but it's not easy to get the standards. Plus, you need to be convincing, let's say, a police officer that an IP infringement is important. Now, frankly speaking, police officers in China are very busy people. At least they do believe they are busy, and they're also much more interested in murders, in very big cases, in this kind of thing than in IP infringement. So criminal prosecution is something for the very big companies. It's much less so for small to medium-sized enterprises who don't have the budget, where the infringement is usually too small to tackle that. Maybe that as a summary.
Hello? Hello, Maarten. Okay, guys, I think we've lost Maarten, so we're going to make sure we actually get back to him by actually calling him. It seems he was traveling from one trade fair to another and was actually at this point in an airport. So probably what the reason why we've lost him, I think my colleague here is going to give him a quick bell, and sure he'll be with us shortly. In the meantime, I'd just like to comment on a few questions we received. I think particularly Raoul and Gabrielle commented on the cost of gathering evidence, cost of making sure. Even Bernard from Germany mentioned the cost of patent monitoring, and we'll certainly tackle this. You can find a lot of relevant information in the various guides that we have at the help desk. One thing's for sure in terms of registering your trademark. This is.
I'm back. Sorry.
Oh, okay, great. Okay, well, I was just commenting on some of the questions we received while we were waiting for you, Maarten. But I'll let you finish with your presentation, and we'll get back to the various questions we've had later on. Okay?
All right.
Perfect.
Sorry. Very briefly, at the end, key messages that I want to leave you with. First is make sure that your IP is protected. And there's nothing that we can do for you if you do not have IP in China, if you want to tackle it in China. So register your trademarks, register your special design patent. If it's copyright, it's very important, then contact us or contact another lawyer to ensure that you can protect that in the proper way as well. Second is understand what is going on in the market. You know your market better than we do. And so if you have the right information, that will be a tremendous help to whoever is going to help you in enforcing your IP rights. A third issue is evidence is everything. So knowing your market is let's say the counter side of that, understanding what's going on and then being able to prove it. If you can prove it, then you do have a lot in hand. A fourth is then to decide what is the best action. what is going to work for you, what meets your budget expectations, what can you get, how can you get tackle infringement in a positive way without spending the rest of your lives on trying to get to a situation that is not possible. Maybe with that, questions, please, Philip.
Okay, fantastic. Fantastic, Maarten. I think we received a lot of comments on the presentation itself. It seems people are very happy. They do, however, have quite a few questions, some of which, actually most of which, relate to costs. Obviously, one of the main issues out there for small businesses is how to manage their IP budget, sometimes on a shoestring budget. So, as I was mentioning to you earlier on, there's a number of quite some comprehensive information in our guides when it comes to registering your trademark, the cost of which, etc. But I think maybe we'll start with one particular question from Bernard in Germany that Jay received. I'll actually pass on the mic to Jay to talk us through that question.
Thanks, Philippe, and glad to have you back now, Maarten. Okay, so this question comes from Bernard in Germany, and he says, as per your comments, he says, if evidence is everything in China, does that mean that an SME needs very elaborate patent monitoring systems in order to find out whether their IP rights have been infringed? And if this is the case, this raises the question of cost of monitoring the market for infringements. So does Maarten have any tips for SMEs in this regard?
Thank you very much for your question, which is a very good one. I would start with this. For SMEs, I do come sometimes across a company to say, well, I think that there's an infringement, but I do also note that it's more that companies are feeling the infringements and that they're noting that their market share is going down, or they can't sell their products, or they're seeing infringements passing by everywhere. That kind of information is not so expensive to get, of course, because that's information that your sales organization is collecting anyway. From your perspective, I mean, when you're talking about patent monitoring, obviously, if you have patents in China which are very valuable, and you have them mainly, for example, for licensing purposes, and you want to license them out, and you want to earn money from that, and you want to find out whether people are not paying that license, then it becomes a whole different matter. I mean, we are working for software clients, for example, where this kind of managing, or this kind of reviewing the market is indeed much more complicated. I think it depends on the kind of business you are in, but I don't have, let's say, easy options. I mean, there's not a good way to monitor the market, a broad market, on infringements of particular patents. I would say that for most companies that we work with, it's not that important, because they will know whether and when their patents are being infringed. I mean, that's when they come to us, and because they're hurt, because their market share is being eroded, and because they can't do their business properly. If your business is not being hurt, if you do not know about a patent infringement, then indeed trying to find out those patent infringements already indicates you have a pretty big budget to protect it, and then I think you're in a little bit different situation.
Okay, thank you, Maarten. And Bernard, if you would like to follow up on that question, don't hesitate to get in contact with Jay. Maybe a follow-up question, really, also relating to costs, was one from Gabriele from Switzerland, who mentioned, again, for small businesses, cost is very sensitive. So how much do the procedures you talked about, Maarten, for example, registering your IP, how much does that, can you put like a number on a typical kind of costs that one business would incur?
Absolutely. Well, normally I wouldn't, but let's make an exception there today. A trademark registration is in my opinion, not so very expensive. I mean, we charge around 5,000 RMB to around 600 euro for registering of one trademark in one class. I believe that there are agents out there who charge much less. You get much less service and much less clarity. There are also companies who charge much more. I would say that if anybody charges more, then come to me. If you want a cheaper deal and you'll take your chances with a local agent, and then there's plenty out there that can be easily found. Registering patents is more expensive. I think we are for design patents usually at around 1,000 euro. That depends a little bit on the situation. For invention patents, this is going to be a much more complicated matter. These costs, you do have to look at it in terms of value as well. I mean, an IP is supposed to be valuable to you. I mean, otherwise you will need to register it. Otherwise you don't need to worry about it. So from that perspective, I think that registering IP is usually cost effective. I mean, if someone finds 600 euro too expensive to register your trademark, then I think that you're not yet at this stage that you need to start worrying about that. To be honest, and of course budgets are there, but registration of IP is just the basis. If you don't register it, you don't have anything. An action is a whole different matter. I mean, I have clients who register IP and who never take an action because they simply don't have the budget. Fair enough. Certain things can be done more cheaply. You can look for cheaper options. I mean, the cease and desist letter, as I mentioned before, 400 or 500 euro, and then you have something. It needs to be proportional to the effect that it has. I mean, if your business model is being eroded, if you're losing market share in your own markets because of an IP infringer in China, then I presume that you have a budget to take care of that, and the bigger your budget, the more effective you can be. However, there's different levels, of course. In some cases, you say, well, it's not that important, but I want to do something about it. If you give me a budget of 50,000, you give me very clear information of who's doing what, and then certainly we can try not only a letter, but you can try a trade fair action. You might even be able to try an administrative action. Yes, we would need a lot of information being done by you, but there are ways to minimize, let's say, required budgets and maximize effect on that. I do have to warn you that if the situation is very dire, if you have 100 infringers who are doing something, then having small budgets is not going to be helpful. And then basically it's probably not worthwhile to do the fight. You come up with your new IP rights, and you have to, let's say, combat the infringers in another way.
Okay, thank you, Maarten, and thank you, Gabriele, for your question. Before we continue with a few other questions, actually, we'd like to open the mic to Rachel Finnegan from TIE, with whom we've organized this webinar, and who would like to make a few comments of her own to add to the conversation here. I think we might have unmuted Rachel. Rachel, I think I can hear the background. Are you with us?
Yes, I am. Thank you very much, Philippe. Can you hear me?
Yes, absolutely.
Perfect. Okay. First of all, I just want to thank Maarten very much for the interesting presentation, and also, of course, the team of the China IPR SME Helpdesk, yourself, Philippe, and Jennifer and Ben, and also to all the participants that have joined. I just wanted to, on behalf of Toy Industries of Europe, make a comment in relation to parasitic copying. Because as I explained to Maarten when we spoke recently, this is one of the issues that is very frequently mentioned among our members when we discuss the issue of IP infringements, particularly coming from China. So it's a very large phenomenon, and it's growing. It's something that really, we see increasing. I was interested to hear Maarten saying that unless the product is actually famous in China, that, well, to me it seemed like you were suggesting, Maarten, that there's very little that we can do. So, considering the fact that a lot of products being manufactured in China aren't actually being sold in the Chinese market, therefore they're not famous in China, is there anything that we can do then to try to, prevent the parasitic copies that we find on the European market that are coming from China?
Thanks for your question. I have to be very honest with you. Under Chinese law, indeed, parasitic let's say trade dress is not protected unless it is a famous good in China. And so, while you can certainly take action in Europe, and it might be an infringement in Europe of your rights, that is as far as you can go. I mean, tackling the European market might also convince an infringer not to send these products out again, but it remains very difficult to take that action to China and to the infringer's doorstep. Of course, there are some, let's say, issues that can be considered. I mean, if they are using your trademark, then that's a completely different matter. If they're using your copyright, if there's certain text that they are copying exactly, then you might have a case there, especially if it's on a large scale. There might also be certain designs that they're copying, which is certainly protected under Chinese law. But purely parasitic copying, let's say trade dress, based on the unfair competition law, where the product is not famous in China, is simply not an option.
Okay, thank you. I mean, that does correspond with a lot of the feedback that we receive from members, basically, that there is the general feeling that it's impossible to do anything about parasitic copying coming from China. As you said, you know, the fact that it doesn't even constitute an infringement. And also, I suppose our members generally report also that they find it very difficult to identify the manufacturers as the parasitic copies in the first place, which obviously leaves them in quite a difficult situation. But okay, thank you very much. That answers my question.
Let's say on that latter point, I mean that can be difficult. Depends on what kind of information is on the box. I would say that finding the exporter is usually not so very difficult. I mean, even through Alibaba, through trade fairs, you may be able to identify something, but taking it further to the manufacturer may be difficult. It's something that the Chinese system at this moment is not changing in this regard. I do recognize, of course, and we all do, and that there's a problem here. But as I said, there's limitations to what can be done.
Thank you.
Okay, thank you, Rachel. Okay. Maarten, maybe to move on to another question from Raul in Spain regarding gathering evidence. Raul asks, quite simply, is there any way to involve or seek help from the Chinese government to administration, whatever it may be, to help gather evidence? Is there any assistance there from the Chinese government when it comes to gathering evidence?
Thank you for your question, Raoul. The answer is, unfortunately, yes and no. I mean, the Chinese, what sometimes companies expect is that the Chinese government is going to do the work for them. I mean, they are responsible for IP enforcement, and they get a lot of pressure from other governments to take action. They promise to take action, and so why aren't they responding more actively from a complaint to a complaint? Unfortunately, the Chinese government is not the biggest priority. That has to be said as well, and they're also very busy doing other things. Basically, the Chinese government can do a lot, and they can gather more evidence. As I said, through an administrative action, they have insights and that you as a private company or your lawyer might not have, but they do need the first step being done by you. I can give an example on the copyright software infringement. We're working for a client in northern China, where the Copyright Bureau, so this is the government department in charge of copyright, they have investigated. They have found out that a company is infringing on our client's rights. They have contacted us and they say, can you take an action? Because we've got all the evidence, but we don't want to take the next step because it's a little bit sensitive. So this is an example where we wouldn't be able to do anything without them having taken the steps to find out what's going on, having evidence, having reports which can be accepted by a court of law on the infringement, on the size of the infringement, etc. So there they have taken that action. They have an interest in it, but even then they can't let's say, hit it home. They can't score the goal. They can just put the ball there, try to put it in front of the goal, and allow you to bring it in. I would say that more often it's the other way around, and that you have to provide a lot of the evidence. And if you provide enough, then they're willing to take, let's say, the last step to really go into a company and make for forceful action, threaten them, fine them, maybe collect further evidence so that you can do a civil lawsuit, etc. I mean, take also a trade fair action. I mean, we are talking about government officers who are sitting there and waiting for you to go there and to file a complaint so that they go with you to the IP booth, see what's going on, and if the IP infringement is confirmed, take action. On the other hand, what we would sometimes like them to do is to take more initiatives. We send them an email. We don't even have to go there. Let them go and check, and they can compare from their own database what infringement, what IP rights there are, compare them with what is there, and then take action. And that is just one step too far. They will not do that. You need to usually take the initiative, and only then they can start helping.
Okay. Thank you, Maarten. I'd like to actually jump back to the issue of parasitic copying. Maybe just for our audience, we've received a few questions on what does parasitic copying actually mean. If you could quickly define that for the audience.
Sure. Well, different. I mean, I certainly know the definition in the Chinese law, but as said, that's not extremely helpful. I mean, different IP rights are involved. Let's take, for example, a toy company who has made a game, who is selling that in Europe, and who sees that a quite similar version of this game is entering the Chinese market. Now, there might be certain IP rights involved. It might be a trademark. They might use the same trademark. Now, often when it's gaming, that's not the name of the game is not trademarked. It could be, but often it's let's say a Mattel, which is trademarked. They might not be using that. It's not necessary to get recognition. So that might be a problem. Secondly, there might be some design copyright issues. But often what companies in Europe are coming across are very similar kinds of, let's say in this case, a game, which has a similar purpose, which has similar questions, which can't really be protected. It has similar colors. It might have a similar kind of labels, but it doesn't use the same trademark. It doesn't infringe on other registered IP rights. It gives a similar feel. It certainly could confuse the market. It could confuse the consumers, but we can't, let's say, touch based on really link it to a specific right. That's what in Europe often is referred to as parasitic copying. I mean, it's unfair competition based. It's a consumer, let's say, confusing consumer on the product, but it's not exactly the same. Now, I know that in some jurisdictions in Europe, this is also a problem. At what level, what do you need to protect? I mean, could they have come up with something similar? How is something similar enough in trade dress or in its appearance as to make a consumer confused? I mean, these are things that are all gray. It's not black and white. I mean, when a trademark is easy, look at it, you have a quick feeling it is the same. But when it comes to a trade dress or parasitic copying, that's part of the problem. And that's why China doesn't recognize it as such as an infringement unless it's famous. Because if it's famous, then we're not so worried that the consumer knows or not knows. Of course it knows. If it's famous, the consumer knows that it's similar, and so it must be a kind of infringement, and so you can do something about it. If not, then you say, well, they could have come up with it themselves. It doesn't mean a whole lot. There's no specific IP rights perhaps infringed. It's just a matter of unfair competition, but it's not really unfair because it's not famous. So we leave it at that.
Is there nothing at the customs level that can be done here, Maarten? For example, you know, if one was to raise awareness amongst customs officials of their particular trademark, their brand and product, as we've seen a few SMEs do, kind of really being active with customs officials, making sure they understand what the product looks like, even organizing trainings with customs officials. Would it be possible to a certain extent to avoid the import of such products to Europe if there was on the part of the SME, a really thorough kind of information provision with patterns?
Okay, that's a very good question.
That's kind of was part of a question from Everett,
okay,
who asked this question just now.
All right, thank you, Edward. Yes and no again. Sorry to be rather ambiguous. When it comes to trade dress, so when it comes to just appearance of the product, no, definitely not. A customs authority can only look at real, straight, direct IP rights. You look at taking it from that. A customs authority takes action on trademarks, sometimes on design patents, very little though. Copyright, sometimes, but very, very little. I think, I don't remember the figures, but I think that more than 90% of customs IP actions relate to trademark, because it is so much more difficult to compare copyright, to compare design patents. Invention patents, forget it, they don't even do it, because they're not technical experts, they don't compare that. So when it comes to customs, what is effective is trademark rights. I mean, you have a trademark in China, you might not generally use it in China, but you have it registered in China, you have those rights. Somebody, a Chinese company is using that trademark, putting it on products in China, and then exporting it to Europe or to Africa or to South America or to the United States or wherever. This is, if a customs comes across this trademark infringement, then they will stop it. They do need to come across it. Yes, you can give training, you can organize sessions, but to be honest, I'm quite familiar with the way that customs works. Customs works on random. They open a couple of containers of every 1,000 and they go through all the products. If they see IP infringement, trademark infringement in particular, then they'll call the owner and they'll say, what's going on? Do we need to do something about this? If that means that all the other containers, if they consist of containing infringers, then they're not going to do anything except if there's a complaint. I mean, if you know that a container of infringing products, and that is including copyright and patents, I would say, but still, especially trademark, if you have the information that infringing products are going to be passing through that customs in a specific shipment, then you can lodge that complaint. And if you lodge that complaint, then they will open it and they will do something about it. So information is key, but I think that in practice, information is relatively rare. You don't have that much information. You might be able to use a private investigator to find something, but it's just not that easy. What is much more common when it comes to customs infringements is that customs actions is that you record at least your trademarks, perhaps some design patents, perhaps some copyright, but at least your important trademarks with customs so that they can more easily find it. And if they come across infringement, they will call you or they will call your attorney and they will give you the chance to seize these products, to stop it, to file a civil lawsuit, and to take an action against that.
Okay, Maarten, that's fantastic. And I think that really concludes today's session. We've had a number of other questions, but I'm afraid we'll have to answer you through our inquiry. And we will answer them, no worries, but we're running a little bit out of time. So maybe what I'd like to do is, first of all, remind you guys that we have a number of publications, guides on the Helpdesk website that will help you navigate trademarks and patents and trade secrets in China, but also how to deal with trade fairs and how to find a business partner, how to deal with what you should know about various IP clauses in your contracts. If you're engaging in R&D in China, what should you do? All of this is in form of guides and e-learning modules on our website. So don't hesitate to visit us. It's of course all for free. You can obviously be in contact with Maarten should you be seeking legal assistance. And I'd like to also highlight upcoming Helpdesk events. If you're in Shanghai, if you're in Beijing, if you're in London, in the next week we'll have a few events. This should be up on the screen right now, so don't hesitate to come down and visit us. Again, it's free. And just really to conclude, I'd like to say, well, thank you first of all to all of you for your time and for your interest. Thank you for Toy Industries of Europe for really reaching out to their members and making this possible. We certainly hope this was of use to all of you. And thank you, of course, to Maarten for a great presentation, all of which was done from the airport. So thanks again, Maarten. That was really good, and obviously we'll be in touch very soon. I'd like to remind you all that this presentation will be available for download in coming days on our online portal under the events section, where you can also find details of future Helpdesk webinars and events. We'll have, if I'm not mistaken, Jay, we'll have a few webinars on enforcement very soon. And for those of you who have friends in the automotive industry, then we'll also have a webinar dealing with that particular sector as well. In any case, it was a pleasure having you all. Thank you, Maarten. Thank you, Kiai, and thank you all of you for attending. We'll certainly hope to see you again. And that's really it from us in Beijing. A great rest of the day for you all, whether it be in China or in Europe. Have a great day. Bye-bye.